Crown on the application of Pearce and another against the Parole Board of England and Wales.
Lord Hughes will explain the court's judgment.
Prisoners who are subject to various categories of long sentence of imprisonment are entitled to have their position reviewed by the Parole Board for decision whether they should be released on licence, under conditions, and subject to recall. Such sentences include life sentences, sentences of imprisonment for public protection, and different forms of extended sentence. The same may apply to prisoners who've been released on licence during their sentence, but have been recalled by the Secretary of State. In all cases, the decision is vested in an independent parole board. The Secretary of State has to give effect to its decision if it decides to release. This case concerned the proper approach which the parole board has to adopt when it's considering whether to direct the release on licence of a prisoner, even though he remains subject to his sentence. By various acts of Parliament, the test for release is always this: is the board satisfied that it's no longer necessary for the protection of the public that the prisoner stay in prison? Mr Pearce is serving a sentence of imprisonment for public protection imposed under the rules then in force for a number of sexual assaults. That, therefore, was an indefinite sentence. So once he had served the minimum term ordered by the court, he was eligible for release on licence conditions if the parole board directed it, applying the test that I've mentioned. If it did not direct release, he would remain in prison under his indefinite sentence. The board convened a hearing before a panel of its members. The Secretary of State chose to make no submissions either way and wasn't represented before the panel. After the hearing, the panel declined to direct Mr Pearce's release, though it did recommend transfer to an open prison as a means of testing his risk to the public. By judicial review, he challenged the lawfulness of the refusal to direct release. His case raised a question of general application as well as the merits of the individual facts of his history. By the time the case reached this court, however, it was no longer disputed by him that the panel had been entitled to find as it did on the facts. But he maintained his challenge on the point of general application. And that point is what is required of a panel if there have been allegations of misbehaviour about the prisoner, quite apart from the offences of which he has been convicted. In Mr Pearce's case, there was recorded material concerning some 7 further alleged sexual incidents, plus a further one of which he had been acquitted at trial. Some were several years ago. They all concerned encounters with women, and several of them appeared, if accurate, to involve significantly similar events in which he'd attempted at night to befriend lone women who were strangers to him. The board's panel took into account this information in relation to 6 of the incidents, to the extent that it found that they were of concern and that they contributed to its assessment of whether it was no longer necessary for the protection of the public for Mr Pearce to stay in prison. It also reached some conclusions about the surrounding circumstances of some of the incidents. For example, in relation to one, it concluded that DNA evidence showed that there must have been some sexual contact. In relation to another, it concluded that his contention that there had been no sexual contact at all was inconsistent with what he had said nearer the time, when he had said that it had been consensual. But what the panel did not do was to go on and fully try out the issue of whether any of the incidents had, on the balance of probabilities, occurred as alleged and involved offences committed by Mr Pearce. In going about it in that way, the panel was following written general guidance, which the whole board had given some time beforehand. That guidance advised panels to consider, when an allegation was made against a prisoner, which of three courses to take. First, disregard it. Second, make findings of fact about it. But thirdly, assess it and decide whether and how it ought to be taken into account. The Court of Appeal held that there was enough in the surrounding circumstances of the allegations, and in particular what Mr Pearce had said about them, to entitle the panel to question the reliability of his evidence and to doubt his ability to self-manage sexual thoughts and behaviour. So the Court of Appeal upheld the panel decision on the facts. That part of its decision wasn't questioned in this court. But the Court of Appeal also held that the general guidance which the board had used was, to an extent, unlawful. It held that a panel could only proceed by way of a two-stage process. First, it must find what facts are proved on the balance of probabilities, and then, second, confining itself only to those facts, it must apply the statutory test. Information, the court held, contained in allegations which were not proved couldn't be taken into account at all. In this court, the argument for Mr Pearce was that the Court of Appeal was right about that. It was argued that the law only knows a binary concept of facts, those which are proved and are taken to have happened, and those which are not proved, which are taken not to have happened. According to this argument, there is no room for a parole board panel to conclude that there is a real risk or a real possibility that an allegation may be true, and no room for taking that possibility into account when asking itself whether it's safe to release the prisoner. This court unanimously concludes that that argument is wrong. The panel is commanded by the statutory test to ask itself whether it's satisfied that it's no longer necessary for public protection for the prisoner to remain in custody. Unless it's so satisfied, he remains in prison under the sentence to which he is still subject. The panel, this court holds, is entitled to take into account any information about the prisoner, including allegations made against him, when it is assessing the need for public protection. There is no warrant, the court holds, for the view that the panel has to proceed by way of the two-stage process suggested. In some circumstances, the real possibility that the prisoner has been responsible for other relevant misbehaviour may indeed bear on the risk to the public which he poses, and it can and should be taken into account. The court goes on to explain that the law doesn't operate any overriding general rule which confines risk assessment to a binary concept of proven and unproven facts. It also rejects a suggested analogy with the different legal process when a local authority applies for a care order asking to remove children from the care of their parents. In that case, it's well established that if the reason advanced for removing the children is that one or other parent has harmed another child in the past, then that previous act has to be proved on the balance of probabilities. Both processes no doubt involve a degree of risk assessment, but they are quite different. The statutory language in the Children Act, in the case of care orders, shows clearly that a real possibility that a parent previously harmed a child is not enough. By contrast, a prisoner who applies for parole is still subject to his sentence, and he stays in prison unless the board is satisfied that it is safe to release him. it follows that the written guidance was not unlawful. However, the court suggests that the terms of the guidance ought to be reviewed in the light of its judgment. A panel ought to consider carefully whether it can and should try out any allegation which is made against the prisoner. Sometimes it may not be possible. For example, if a witness declines to be available, or if the necessary information is incomplete. Sometimes it may be positively unfair to the prisoner to try out an allegation if there is likely to be a criminal investigation or prosecution based on it, because in that case the panel might preempt the decision of the subsequent court and moreover do so applying a lower standard of proof. Moreover, the prisoner might be put at a disadvantage because he would normally be entitled not to answer questions about the allegation. There may be other situations also where it's not practicable to try out the allegation. But the court holds that the panel should try out allegations where it is reasonably practicable to do so, and that its duty to act with procedural fairness requires it to give the prisoner the opportunity to make arguments about how it should proceed and whether it should do so or not. For those reasons, the appeal against that part of the Court of Appeal order which held that the guidance was unlawful is allowed.
The court will now adjourn.